Hi, I'm Andrew Lloyd. I'm Head of Employment Law here at Lloyd Donnelly Solicitors. Well, this can be broken down into four main rights. First of all, there's the right to paid time off for antenatal care. There's also maternity leave. There's the right to maternity pay in some cases, and more importantly, the right not to suffer a detriment as a result of being pregnant or taking time off. Well, before you're entitled to those rights that I've just discussed, you first of all need to actually tell your employer that you're pregnant. Now, this needs to be done at least 15 weeks prior to the expected week of childbirth. Now, in some cases, of course, that's not possible. Some women, believe it or not, don't realise until very late on that they're pregnant. In those circumstances, you need to tell your employer as soon as possible. And in any case, you need to give your employer enough notice prior to when you intend to start maternity leave and therefore receive maternity pay. Right, now when we talk about antenatal care and time off for it, we don't just mean appointments with midwives or doctors or consultants. We also mean, for instance, antenatal classes. So your GP or your midwife may have recommended that you have parenting classes, to deal with childbirth and thereafter. So you've got the right to time off to attend all of those sorts of classes as well, not just the medical ones. Right, well, every woman who is in employment in the UK is entitled to take maternity leave. It doesn't matter whether you've been there 10 days or 10 years. By reason of the fact that you're in employment, you qualify for maternity leave. Well, the good news is that you get a year. You get 52 weeks that you can take off from your job when you have a baby. You don't have to take all of that, but there is a minimum requirement that you take at least 2 weeks off after the birth of your child. Well, this is the question on most people's lips when they come to a solicitor for advice. Now, whilst everyone can take maternity leave, not everyone gets maternity pay. And in order to qualify for maternity pay, you need to have been employed at least 26 weeks before the 15th week of the expected week of childbirth. And I can imagine that's a little bit confusing. So what you do, you take your expected week of childbirth, you count back 15 weeks, and then you must have been employed for 26 weeks at the 15-week point before childbirth. Well, this is another popular question. For the first 6 weeks of your maternity leave, you actually get 90% of your salary. Thereafter, it goes down to £135 per week for 33 weeks. Now, that's just your statutory entitlement. It could be you work for a generous employer, and as part of your contract of employment there, they may be willing to provide you with a contract payment for perhaps even your whole salary during your maternity leave. But in terms of the minimum statutory entitlement, it's 6 weeks, 90% of your salary, and then 33 weeks of £135. Now, you need to give your employer at least 28 days of when you want to start your maternity pay. And in order to do that, you need evidence of when your baby is due. Now, you can do this in one of two ways. Either you can get a letter from your GP saying when the baby is due, or alternatively, you can get a certificate called a MAT B1 certificate from your midwife, and that will do the same thing. That will say when the baby is due. Well, this is one you need to be very careful with. The law does allow you to come back for 10 days, so that's 10 separate keeping in touch days is what we call them. However, that's about it. So what you can't do is come back to work for a few weeks and receive maternity pay. As soon as you've come back to work, you lose your maternity pay. Well, the good news is that even though you're off work receiving maternity pay, you still actually accrue holiday pay. Most women like to take this perhaps a month before their maternity leave starts, or alternatively, they could take it after. And if you can imagine, if you're off for a whole year, you've got a whole year's leave to take one way or the other. What we advise our clients to do is perhaps let their employer know well in advance of when they want their maternity leave to start, and they get an extra month at the beginning of their maternity leave on full pay, or a whole month perhaps at the end of their maternity leave on full pay, using their entire holiday entitlement. Well, that depends. If you've taken less than 26 weeks maternity leave, and therefore maternity pay, you're entitled to come back to exactly the same job that you did before you went off on maternity leave. That's an absolute guarantee. If, for instance, you've taken longer than 26 weeks maternity leave and maternity pay, you're entitled to come back to work, but your employer doesn't necessarily have to give you your exact job. He can redeploy you to another role. But the important thing about that is the new role that your employer has given you cannot be any less beneficial to you in terms of pay and conditions. So you can move into perhaps another department or a slightly different job role, but it must be on the same pay or better pay and no worse conditions. Well, unfortunately, yes, you can. However, your employer's decision to select you for redundancy cannot be on the grounds of you're pregnant or that you've taken maternity leave or receiving maternity pay. That's sex discrimination, and if that happens, you can make a claim to the Employment Tribunal. Unfortunately, we get many calls from women whose employer is going through a redundancy procedure, and it looks like they were the ones selected for redundancy either because they've been forgotten about or the employer just simply doesn't want to retain employees on maternity leave. Well, the good news is, even if you are made redundant, you're still entitled to your maternity pay. So if, for instance, whilst you're off on maternity leave, your employer gives you notice that you're redundant, you've still got the right to receive your maternity pay up until the 39 weeks. Alternatively, if you're even dismissed or made redundant before you've gone off maternity leave, provided you qualify for maternity pay, you'll still get your maternity pay in addition to your redundancy pay. Well, yes, you can, provided that your employer agrees to it. Now, the important thing is that there's no automatic right to come back to work on part-time hours. Your right is to come back to the job that you were doing before on no less beneficial pay. So if you want to come back to work part-time, you're asking your employer to amend your contract. Now, that can be done in agreement with your employer. And you need to submit what we call a request for flexible working. You can ask to come back part-time. You can even ask your employer if you can perhaps even work from home a few days just to ease you back into the working environment. If your employer refuses to allow you flexible working, he's not necessarily breached your employment contract or breached your employment rights. However, if the reason why he doesn't want you to come back to work part-time is related to your sex, again, that might be sex discrimination. For instance, if the rule is indirectly discriminate to more women than men, you may have a claim for sex discrimination. The important thing is to seek advice whenever your employer has refused you to come back to work flexibly. It might be that we can persuade the employer to change his mind. Right, well, first of all, not every dismissal of a pregnant woman is going to be unfair or sex discrimination. The employer may have a perfectly legal, valid reason to dismiss the employee. However, in a lot of cases, it's very suspicious, and employers, unfortunately, still these days, have a prejudice towards pregnant women. They don't want to pay maternity pay, they don't want to have to cover their maternity leave, and they think of a reason to dismiss the employee. It could be their work performance, it could be another reason. The important thing is, if this has happened to you, you need to pick up the phone straight away and you need to seek advice from a solicitor. You've only got 3 months from when your employer tells you that you're dismissed to make a claim, so time really is of the essence. If this happens to you, unfortunately we get many calls from women in similar circumstances, we're able to flush the truth out, and we've obtained very good settlements for women in the past who have been dismissed in these circumstances. Well, the good news is that at Lloyd Donnelly we offer no-win, no-fee agreements. It's called a contingency fee agreement, and it means that there's no upfront charges, and you only pay your solicitor if you've won something, and it's normally a percentage of the compensation that you receive.